So good morning, everyone, and welcome to this quick update webinar. We're going to feed you information. It's going to take less than 30 minutes, and I hope that by the end of it, you'll be wiser than at the start of it. We're going to talk about three issues today. We're going to talk about the deadline for updating international transfers where UK GDPR applies. We'll talk about the deadline for updating international transfers where EU GDPR applies, and we'll talk about the new Information Commissioner's Office guidance on TIAs and TRAs. And those are impact assessments for international transfers. So my name's Joanna Bogue-Thompson. I'm a partner in the Media and Technology team at Shepherd and Wedderburn. And I'd also like to introduce you to my colleagues, Ashley McLean. Ashley's a senior associate in our Media and Technology team based in Edinburgh. And my other colleague, Joe Fitzgibbon, who's a senior associate in our Media and Technology team based in Glasgow. And over the last weeks and months, we and our other colleagues in the Media and Technology team have been working on international transfers. And in our experience, many clients are still working under old transfer mechanisms and haven't really thought about what they need to do to update their practices on international transfers. Now, we thought that by now the ICO would have provided guidance on using their new templates. Unfortunately, they haven't, although they have provided some other guidance. And that's why we're running this short session today. And if you need to watch it again, we'll make a recording of today's session available on our website, and that should be available later today. So just a quick introduction. The EU GDPR and its predecessor, which was the Data Protection Directive back in the mists of time, they created a framework for ensuring that personal data is protected once it's moved outside the European Economic Area. And as we've come to know, those of us who practice in this area, it's not always entirely straightforward to comply with this framework. And that's particularly because European case law keeps moving the goalposts. And that happened most recently in 2020 with a case known as Schrems II. And this case had a really significant impact on international transfers. And it may seem like some time ago, but that impact's still being felt. And as a result of the Schrems II decision, the EU issued new standard contractual clauses in the summer of 2021. And those of you who know about data protection will know that standard contractual clauses tend to be the most used method for papering international transfers. However, those were issued in the summer of 2021, but Brexit meant that in the UK we could only use the old standard contractual clauses adapted for the UK.
So, Joanna, you mentioned that Schrems II was a significant judgment that was handed down in when it was handed down in 2020. So, what is the position on Schrems II just now?
Yeah, I know. I mean, it seems strange that we're still talking about Schrems II. But as a result of it, all organisations should have been updating and reviewing their transfers to third countries to address the Schrems II issues. So what that means is putting in place additional protections to address the issues of access to data by law enforcement authorities in certain countries. And most often by that, we mean the US, where they use that access for surveillance purposes. So if you're a UK company and you're using the pre-Brexit standard contractual clauses, then they may not be Schrems II compliant. And you'll only really be able to confirm that position if you carry out a transfer impact assessment. And that's something that Joe's going to talk to us a little bit more about later on in this session.
So what is the deadline for updating international transfers when UK GDPR applies?
Okay, so if you entered into the old EU SCCs on or before the 21st of September 2022, that remains a valid means of making international data transfers until the 21st of March 2024. Okay, so from 21st September 2022, you should have been using new mechanisms. So there is that date of 21st March 2024, but If the processing operations have changed from those that were envisaged in the original contract, or if they change in the future, or if you enter into a new arrangement, this needs to be done under one of the two mechanisms that the ICO has provided, the International Data Transfer Agreement or EU Standard Contractual Clauses with a UK addendum.
So what is the deadline for updating international transfers for EU GDPR applies? I believe it's coming up pretty soon.
It absolutely is. So if you're subject to EU GDPR and you have the old standard contractual clauses in place, you need to update to the new standard contractual clauses before the 27th of December this year. So that is 3 weeks from now.
Right, yeah, so only a matter of weeks until that deadline. So on that note, could companies outside of the EU be subject to EU GDPR?
Yes, absolutely. So a lot of companies will have an establishment within the EU, and that brings them into EU GDPR. But there's also Article 3.2 of the EU GDPR, and that covers what we call extraterritoriality. And you're subject to the extraterritoriality of EU GDPR if you offer goods or services in the EU. So that's quite an easy test to understand. But you can also be subject to the extraterritorial reach of the EU GDPR if you track EU citizens. And that might be as straightforward as using online tracking through the use of cookies.
So do you come across many companies, many UK companies that are subject to EU GDPR?
Actually, we do, yep. And that's because the extraterritoriality provisions apply more often than people think. And I gave you an example, Ashley, of the position where a company might use cookies for online tracking, and that tracks the behaviour of EU citizens, and that can be enough to bring a UK company or a US company within the purview of EU GDPR's extraterritoriality. And a lot of companies already know about this. So a lot of companies have already taken steps to comply with the extraterritoriality elements of EU GDPR. And we see that when companies appoint an EU representative. And the reason we know about that is because we offer this service to clients through our Irish subsidiary Saltire Data Protection Services Limited. So some companies are aware that they fall within EU GDPR, but a lot of companies are not aware of it and don't always do the tests to see whether they are. And I guess the other thing is, of course, you can be subject to EU GDPR and you can also be subject to the UK GDPR as well.
So I guess moving on to the UK position then, does the UK GDPR still take the same approach to international transfers as the EU GDPR?
I'd like to say yes, it's yes and no, but really it is yes as a simple answer. But we use different documentation to get to the same effect. So the ICO has issued two templates. The first is the International Data Transfer Agreement template, and the second is the UK addendum to the new EU SCCs. And UK companies can elect to use either of them.
When would you expect to use the International Data Transfer Agreement, the IDTA?
So the IDTA is more likely to be used where transfers are only subject to UK GDPR. Okay, so they'll primarily be used for transferring data only from the UK to a third country. And so the IDTA is really for use by organisations that are UK based and are subject only to the UK GDPR. And there's a template of the IDTA available on the ICO's website. It's a full form standalone agreement. It's probably fair to say that its language is a bit more user friendly than the SCCs, which are drafted with typical European language. And it also allows for arbitration for dispute resolution, and that can be quite a useful thing. It's just never quite as straightforward to use as you would like, because you need to fill in a number of tables and you need to make some assessments on options. But we've developed experience of using the IDTA, and we can help clients to put an IDTA in place. There is something missing from the IDTA. So it doesn't have the Article 28 processor clauses. So those are the mandatory clauses where a controller is appointing a processor. Those are contained in the EU SCCs, but the IDTA assumes that you have a linked agreement that contains those clauses. There's one other advantage to the IDTA, which is that it can cover transfers to organisations located in third countries, even if the data importer in that country is directly subject to UK GDPR, which also has extraterritoriality. The SCCs don't cover transfers where extraterritoriality applies to the importer of personal data. That's quite a technical point though, Ashley, so I'm not going to go into any further detail on that particular point just now.
Understood. And so that was a really helpful explanation of when you would use the IDTA, but when would you then expect to use the UK addendum to the SCCs?
Yeah, so the UK addendum it's relatively short, and it amends the new form of the EU SCCs so that they can be used to make international transfers of personal data from the UK. And for multinational organisations with a multinational or a global presence requiring frequent transfers of data from the UK and from the EU to a third country, the UK addendum, I think, is the better option. And that's because it makes sense for these sorts of organisations to use the UK addendum to fold in their data flows from the UK into the EU SCCs. And it's usually the case that corporate groups that have a presence in the UK and also in the EU will want to use just one data transfer agreement to comply with their requirements across both jurisdictions. That's both the UK and EU jurisdictions. And so that will usually mean using the EU SCCs plus the UK addendum. And the EU SCCs follow a modular format. So you've got 4 options under them. You've got data controller to data processor, processor to sub-processor, processor to processor, and then processor to controller contracts. So those modules are quite useful as well.
So what else should companies be doing? What else should they be thinking about?
The key point, I think, is also to be doing some risk assessment. And there's talk about TRAs and TIAs, and I'm going to pass you across to Joe just now, and Joe will talk about them. Thanks, Joe. Over to you.
Thank you, Joe. So many of you last month will probably have spotted the UK Information Commissioner's updated guidance on international transfers. This guidance includes a new section on transfer risk assessments, which Joanna said are known as TRAs, and also a new TRA tool. Unfortunately, as Joanna has also said, this was not the early Christmas present that many of us might have hoped for. I think the more welcome Christmas present would have been some updated or some guidance on how to use the ICO's International Data Transfer Agreement and the addendum to the EU SCCs, but we'll all have to wait a little bit longer for those. Nevertheless, this new guidance I do think is welcome, and the ICO touts the TRA guidance and tool as an alternative approach to the similarly named transfer impact assessment put forward by the European Data Protection Board. The ICO believes that this approach will deliver the right protection for data subjects while ensuring that the assessment is reasonable and proportionate, keywords. The ICO's focus on the TRAs being achievable will be welcomed by many of us grappling with the compliance obligations related to international data transfers. And today I'll highlight some of the differences between the ICO and European approaches as we take a further look at the TRA tool. So what is a transfer risk assessment, I hear you ask? Well, if you're transferring personal data internationally and are relying on the transfer mechanism in Article 46 of the GDPR, which will most commonly be the ICO's IDTA, or the addendum to the standard contractual clauses, or indeed binding corporate rules, you must carry out what we refer to as a transfer risk assessment. And this is an assessment that will help you consider if the transfer and the use of your chosen transfer mechanism will undermine the relevant protections for individuals under the UK data protection regime. So the ICO's TRA approach focuses on assessing whether the specific transfer increases the risks to people's privacy and other rights compared with the risk if the personal data simply remained in the UK. If there is no significant additional risk, the transfer may go ahead. Given that the importer will be bound to comply with the data protection rights under the Article 46 transfer mechanism, the TRA tool focuses mainly on the more general risk to human rights in the destination country. And there are two broad types of rights that you must consider in your TRA. Firstly, the risk to people's right arising in the destination country from third parties accessing the information, where those third parties are not bound by the Article 46 transfer mechanism. In particular, we're talking about governments and public bodies. Secondly, you must consider the risks to people's rights arising from difficulties in enforcing the Article 46 transfer mechanism. So how does the structure of the TRA tool help you assess these risks? Well, the TRA tool is a template document with 6 questions and guidance on how to complete the TRA. It gives an initial risk level for categories of data and, according to the ICO, has moved the focus on whether the transfer significantly increases the risk of either a privacy or a human right breach, as it believes this captures the key risk to the people the data is about. So question 1 of the TRA tool requires detailed information on the specific circumstances of the restricted transfer. And this, in effect, is very similar to what the EDPB guidance seeks. Question 2 assesses the personal data risk level. If the assessment in question 2 concludes that all categories of transferred data are a low harm risk, the transfer can go ahead without the need for further assessment, as regardless of response to the following questions, the nature of the personal data and the circumstances of the transfer mean that the risk of harm to the people is low. However, if this is not the case, the assessment must continue. And I think it's worth pausing here to note that this is probably the first notable departure from the EDPB transfer impact assessment approach, which disapproves of the argument that the nature of the data is irrelevant to the risk of foreign government access. Moving on to question 3, this aims to determine what is a reasonable and proportionate level of the TRA investigation, given the data risk level and, interestingly, also the nature of the exporter, specifically its size and the resources available to it. This is effectively assessed by reference to the data protection fee tiers that we have in the UK. Question 3 uses an investigation matrix to take account of the level of risk associated with the transferred data, its volume and the size of the data exporter, as I've already mentioned. And this is to decide which 3 levels of investigation is required when addressing subsequent questions 4 and 5. Small and medium-sized enterprises are only ever expected to apply the level of investigation in 1 or 2, which means relying on publicly available reports, such as the Foreign and Commonwealth Office's Human Rights and Democracy Report, or other reports such as the Amnesty International report, The State of the World's Human Rights. These are both level 1 assessments. A level 2 assessment, an example of that is further internet-based research, for example, review of human rights reports from other governments or charitable organisations. The requirement for the detailed analysis about the treatment of human rights in destination countries has been reserved for large businesses only. So I can hear a sigh of relief for the small and medium-sized enterprises out there who don't have to take on that additional burden. Again, as you might expect, this is a marked difference from the EDPB's approach. The EDPB makes no distinction in the expectation of what an exporter has to do. Therefore, a micro business with a handful of employees has to undertake the same analysis as a global organisation. Looking at question 4, this examines whether the transfer significantly increases the risk of a human rights breach. The word significant suggests a divergence from the EDPB's stricter interpretation of risk and the near zero risk approach demonstrated by some European regulators in their enforcement activities. Question 5 establishes whether the transfer mechanism is enforceable against the importer in the UK or, if needed, in the destination country. Again, this takes a risk-based approach, and risk-based is wording you'll hear often when I refer to the ICO's approach to data transfers. So this takes a risk-based approach, and it takes it further than the EDPB, acknowledging low likelihood of enforcement being needed for data that poses a low or moderate harm to risk. So organisations may proceed with the transfer only if the assessments in question 4 and 5 do not identify any data with a human rights risk or an enforceability risk. If such data is identified, organisations must then consider question 6, whether any of the exceptions to the restricted transfer rules apply to such data. The transfer can only then go ahead if one or more of the exceptions in question 6 apply to the significant data that is at risk in questions 4 and 5. If the exceptions do not apply, so that's the exception in question 6, if they do not apply, organisations may not proceed with the transfer. So that's quite a lot to take in, and I really would suggest having a look at the tool. But the question you may be asking is, what approach should I take? Well, the TRA approach proposed by the OCA appears on the face of it to be more pragmatic, more risk-based and business-friendly than that based on the EDPB guidance. So it will be useful for UK-centric organisations that are subject to the UK GDPR, especially SMEs and those whose data does not involve any EU data. For larger organisations, as Joanna has already mentioned, who may be using the EU the UK addendum to the EU SCCs, for larger organisations such as that, transferring data internationally, whose data flows comprise both EU and UK personal data, they are likely to already be using the UK addendum and SCCs. And it's most likely that to maintain a unified approach to their contracting, that we'd expect them to continue to use the EDPB's TIA approach, especially given that the ICO is comfortable with organisations using either of the two alternative approaches. And I think that's an important point. The ICO is pretty comfortable whether or not you're using its own TRA tool or indeed the transfer impact assessment that's very common in Europe. So what next? Well, finally, it's worth noting that there is more guidance to come from the ICO in this area. It does have plans to publish worked examples of the TRA tool, which will be welcome to many of us. And as Joanna said, we'll also keep an eye out for the much needed guidance around the use of the UK IDTA and the UK addendum. Hopefully a late Christmas present expected in the new year. So Jo, I'll now hand back to you.
Thanks very much. So yes, interesting, I think, isn't it, that the ICO is happy with the EU's TIA, but we don't know if EU regulators will be happy with the ICO's TRA. So in conclusion, firstly, check the position on your international transfers. Do you have a TIA or a TRA in place? If you don't, please do one. If you have an old impact assessment, check that it covers the Schrems 2 risks and use the ICO website to help. As Jo says, at the moment, they've got the TRA up there and they intend to have worked examples. Just now, there aren't any worked examples, so if you do need help, please feel free to come to us. If you're subject to EU GDPR, make sure that you have repapered your standard contractual clauses to update them before the 27th of December this year. That's 27th December 2022. If you're also subject to UK GDPR and you're using the EU's new SCCs for EU and UK transfers, make sure you have the UK addendum in place by the 27th of December. And if you're only doing international transfers that are subject just to UK GDPR and you're working to the March 2024 deadline, start thinking about it now. It comes round much sooner than you think. So I hope you found this session useful. I promised that it would be less than half an hour. Do please get in touch with any of us if you need help. And thank you very much indeed for your attendance, and goodbye.